Let's take a look at visa programs from an employment law perspective. Foreign nationals who do not have permanent resident status must obtain visas that will permit them to work in the United States. Many visa classifications have been established to accommodate the various types of foreign national workers. Students from other countries typically come to the United States under the F1 or J1 visa classification to receive optional practical training related to their course of study. F1 visa holding students can be employed for up to 12 months. Employer sponsorship and conversion to another visa classification are required to continue in longer term environment and employments. H-1B visas are granted to persons in specialty occupations requiring a bachelor's degree or higher in the field. Typical occupations for recipients of these visas include systems analysts, engineers, architects, and accountants. Employers argue that the number of these visas must be increased if U.S. companies are to stay competitive in scientific and technological endeavors. Critics contend that there's no real shortage of skilled workers in the United States and that employers simply want to drive wages down. Employers that want to hire foreign nationals with H-1B visas first must file Labor Condition Application or LCA forms with the Department of Labor for each occupation in which foreign nationals will be employed. Employers must attest to a variety of conditions, including that they will pay their H-1B visa holders the great and local prevailing wage of the employer's actual wage and offer benefits on the same basis as their U.S. workers. Employers with 15% or more H-1B holders must attest that they have not displaced U.S. workers by hiring them and that the qualifications of H-1B hires are better than those of any American applicants. Employers that want to terminate H-1B visa holders prior to the end of their contracts must notify the U.S. Citizenship and Immigration Services and may have to pay for the return of those workers to their home country. H-2 visas are for foreign nationals who come to the United States to perform work on a temporary basis. H-2A visas are reserved for temporary workers in agriculture or logging, and H-2B visas are intended for temporary workers in other industries not including nurses. Applications for H-2 visas must be supported by evidence showing that there are too few U.S. workers available to perform the work and that the use of foreign nationals will not adversely affect the wages and working conditions of U.S. workers. H-2A visas for temporary agriculture workers carry many additional stipulations, including an employment contract, reimbursement for travel costs, free housing, and a minimum number of work hours. The DOL establishes adverse effect wage rates for H-2A visa holders. That is, minimum rates that employers are required to pay and that are set at levels calculated to avoid adverse effects on the wages of U.S. workers in the same job categories. L-1 visas are designed to allow multinational companies to temporarily transfer staff from foreign facilities or subsidiaries to operations in the United States. Companies using L-1 visa holders must station these employees at companies' own facilities and retain ultimate supervisory authority over them rather than contract them out to other employers. Employers that recruit non-immigrant foreign nationals must be prepared to comply with the numerous and varying requirements attached to the different visa classifications.